Hi, my name is Mason Waring. I'm joined here with my colleague, CCK attorney Leah Small. And today we're going to talk about the three phases of a long-term disability claim. We're going to talk about the initial claim, the administrative appeal, and litigating your case in court. So let's get started, Leah, by talking about the initial claim process.
So the first step is submitting notice of claim to the insurance company. And once you do that, they'll typically send you claim forms to fill out, which is typically forms for the claimant, forms for the doctor to complete. The insurance company will also gather evidence at that point once you submit your forms from your medical records, maybe additional evidence from your doctors. And it's important, though, as a claimant, not to rely on the insurance company to do that during the initial claim process. It's really important for you to gather your medical records yourselves and submit them for a couple different reasons. First, it makes sure that the evidence actually gets to the insurance company, which will need to evaluate the claim. But it also allows you to see if there's anything that seems to be missing from the records or anything your doctor should address in a more substantive report separately. But once the claim forms and all the evidence has been submitted, the insurance company will do its investigation. At that point, they'll either approve your claim, which is great, you're now receiving benefits once you've exhausted the waiting period, or they'll deny your claim. And if your claim is denied, you then move on to the second stage of the process,
which is the administrative appeal. And you hope to not have to go there, but sometimes you do, and various things can happen. Sometimes the insurance company disagrees with you and says, we don't think you're disabled. Sometimes it's missing information. There can be a whole number of reasons why your claim may be denied. Leah, can you talk about that appeal process?
So the appeal process can be a really good time to get an attorney involved because it's typically the critical stage, especially when your claim is governed by ERISA, which means typically that your coverage was received through your employment. It was an employment benefit. Oftentimes, the appeal can be your last chance to get evidence into the record in support of your disability. And so it's really important. Read the denial letter carefully to understand what was the basis for the denial. Was it, as you mentioned, missing information? Did they say the information doesn't support your disability? Was it something else? To make sure you're gathering and providing whatever is needed to address that denial and establish that you are disabled and entitled to benefits. Beyond just reading the denial, though, it can be a good idea, and you are entitled to receive a copy of your claim file from the insurance company. And that gives you even more information about their decision. It lets you see their internal notes, any medical reviews they obtained, any vocational reviews they obtained, and again, gives you more detailed understanding of their denial and tells you what exactly you need to do in order to challenge and hopefully overturn that denial.
And it should have all those items in there.
Right.
It doesn't always. So sometimes there's information missing from the claim file. Everything that was submitted, generated, or considered with respect to the claim by the insurance company should be in that file, but there are often things missing, and we have to follow up with the insurance company to make sure those things are part of that file. Leah, after the administrative appeals filed, if it's approved, benefits paid, that's great. If the appeal is denied, what's the next step?
If the appeal is denied, typically claimants are looking at filing a lawsuit in court to challenge that denial. And this is generally kind of the last opportunity to try and obtain benefits. Obviously, there can be levels of appeal in court, but if you lose on appeal in court, that's it. Unfortunately, you don't receive your benefits. As we mentioned, oftentimes in court, when it's an ERISA-governed claim, coverage you obtain through your employment, you are limited to that record you built during the initial claim and administrative appeal process. And so again, that's why it's really important to make sure in those earlier stages, you've gathered and submitted all necessary evidence to establish your disability. Sometimes in court, depending on your jurisdiction and the terms of the long-term disability policy at issue, the court may actually give deference to the insurance company, which means they will not simply be looking at whether their decision was right or wrong and whether you're entitled to benefits or not. They may just look at, did the insurance company have a reasonable basis for denying your claim, unfortunately. Sometimes in court, you may have the opportunity to settle your claim with the insurance company without always having to go through the entire litigation process. But, that's not guaranteed. And so typically if you're filing suit in court, you have to be ready to, litigate to the end. And that can unfortunately be a very long process, months, years long before you have a decision one way or the other.
The nice thing is we do most of the work.
Right.
And so the burden on our clients in terms of like time commitment and things like that tends to be very low. We do the heavy lifting in terms of dealing with the insurance company, dealing with the court. Another important point here is that, Leah provided a really good general overview of the typical claim process. It can vary, initial claim, appeal, and, how and when you're able to go to court, depending on the terms of your policy. So as we always say, really important to get a copy of your policy, read and understand what rules apply to your claim. If you have any questions about your claim, if you need to file an appeal, or help with any phase of a long-term disability claim, please reach out to us. It costs nothing to speak with us to see if we can assist. Our number is 401-331-6300. You can find us online at cck-law.com. Please like this video, subscribe to our YouTube channel, and leave a comment if there's some topic you'd like us to cover in the future. Thank you.